Friends, good morning. I am going to discuss a very important topic about implementation of caveat in case of writ petitions. There is a lot of confusion whether we can file a caveat against the writ petition or not. As different high courts are having different rules, so I am going to discuss in detail. Be connected with me. Now, as I had told, my topic today is whether Section 148A of CPC applies to writ petitions filed under Article 226 of the Constitution of India. To understand whether the Section 148A CPC apply to writ petitions under Article 226, we have to examine Section 141 of CPC. What the Section 141 says? It states that the procedure provided in CPC regarding suits shall be followed as far as it can be made applicable in all proceedings in any court of civil jurisdiction. I am again repeating what is Section 141 of CPC. Section 141 deals with miscellaneous proceedings. The procedure provided in this code in regard to suits shall be followed as far as it can be made applicable in all proceedings in any court of civil jurisdiction. There was amendment of this section in 1976 and explanation was added to it. So afterward, what is the shape of this section 141? I am reading it completely so that it may not create trouble in understanding what I want to say. Section 141 Miscellaneous Proceeding. The procedure provided in this code in regard to suits shall be followed as far as it can be made applicable in all proceedings in any court of civil jurisdiction. Explanation. In this section, the expression proceedings includes proceedings under Order 9, what does not include any proceedings under Article 226 of the Constitution. So, to remove confusion, this explanation was added, which is clearly saying that in case of writ petition under Article 226, Civil Code does not apply. Now, coming to what is caveat, it is dealt under Section 148 of the 148A of the Civil Procedure Code 1908. It talks about right to lose a caveat. Its first section says where an application is expected to be made or has been made in a suit or proceedings instituted or about to be instituted in a court, any person claiming a right to appear before the court on the hearing of such application may lose a caveat in respect thereof. Second subsection says, where a caveat has been lodged under subsection 1, the person by whom the caveat has been lodged, mean to say caveator, shall serve a notice of the caveat by a registered post, acknowledgement due on the person by whom the application has been or is expected to be made under subsection 1. Now coming to subsection 3, where after a caveat has been lodged under subsection 1, any application is filed in any suit or proceeding, the court shall serve a notice of the application on the caveator. Fourth subsection says, where a notice of any caveat has been served on the applicant, he shall forthwith furnish the caveator at the caveator's expenses with a copy of the application made by him and also with copies of any paper or document which has been or may be filed by him in support of the application. Last subsection says, where a caveat has been lodged under subsection 1, such caveat shall not remain in force after the expiry of 90 days from the date on which it was lodged, unless the application referred to in subsection 1 has been again made before the expiry of said period. So this caveat has validity of 90 days if not again submitted. Now I am discussing one case law, that is Babu Bhai Muljibai Patel versus Nandlal Khoti Das Barrett. In this case, our Honorable Supreme Court observed that the words, as far as it can be made applicable in section 141, makes it clear that in applying the various provisions of the code to proceedings other than those of suit, the court must take into account the nature of those proceedings and the relief sought. The court further observed that since the object of Article 226 is to provide a quick and inexpensive remedy for aggrieved parties, if the procedure of suit was followed in case of writs under Article 226, the entire purpose of remedy will be defeated. Now, coming to Bombay High Court, Bombay High Court on 12th May 2021 issued two separate notifications under Article 225 and 226 of the Constitution of India, amending both the original and appellate side rules of the Bombay High Court, expressly stating that the Section 148A will not apply to writ petitions under Article 226 of the Constitution. Now, as I already told, Section 148A CPC deals with the right to lodge a caveat in any suit or proceeding instituted or about to be instituted in a court. Therefore, as a result of these amendments to Bombay High Court rules, no caveats can be filed in proceedings that may arise under Article 226. Coming to Andhra Pradesh High Court, Andhra Pradesh High Court has held that Section 141 apply to writ petitions under Article 226. So Andhra Pradesh High Court is allowing caveat. Now coming to Allahabad, Calcutta, Madras, and Punjab and Haryana High Court had held to the contrary. It is for this reason that CPC was amended by the Union Legislature by CPC Amendment Act 1976. Explanation to Section 141 was added, clarifying that the expression proceedings includes proceedings under Order 9 CPC, but does not include any proceeding under Article 226. Musaji Muhammad Ali, Master and Son versus Ghulam Mali Dadubai Amreliwala case. In this case, Bombay High Court interpreted the explanation to Section 141 and held that explanation will apply to writ petitions filed under Article 226 but not to Article 227. Because there was mention of 226 in explanation. That's why the judgment said that this explanation will not apply to Article 227. Now coming to views of various high courts, compiling up my project. The Kerala High Court in KP Harikrishnan versus C.K. Jaku, after interpreting the relevant rules of its High Court rules, held that No caveat petition is maintainable in proceedings under Article 226 of the Constitution. They are taking into consideration their High Court rules along with this, you can say, amendment. Delhi High Court in Deepak Khosla versus Union of India went one step further to observe that Section 148A cannot even apply to petitions filed under Article 227. Rajasthan High Court in H.G. Shankar versus State of Rajasthan interpreted Rule 159 of its Rules 1959 to hold that caveats can be filed in proceedings arising out of Article 226. Now, then again, there is one case, Apsara Theatre, Bijapur case. The Karnataka High Court held that since Rule 39 of Part 4 of High Court's Writ Proceeding Rules 1977 provides that the provisions of CPC would apply to petitions under Article 226 and 227. So the provisions contained in Section 148A would automatically apply to writ petitions. Now, there is another case of Odisha High Court, Jageshwar Bhai versus State of Odisha. The Odisha High Court held CPC procedures will apply to writ under Article 226, not because of any compulsion to do so, but because that procedures accord with the rules of natural justice and also rules of Odisha High Court under Part 2, Chapter 6 provides for caveat to be lodged where a petition is lodged or expected to be lodged, but writs in the nature of habeas corpus were excluded. So Odisha High Court allowed the everything, but it excluded habeas corpus writs from the its section. Concluding comments. One can conclude that though the explanation to Section 141 CPC excludes application of its procedure to the proceedings under Article 226 of the Constitution of India, but where the rule of a particular High Court provides for filing of caveat for petitions under Article 226, such rules have been held to take precedence over CPC. Hence, our Honorable Supreme Court, to bring uniformity on caveat law, should lay down the law on this issue. I am strongly recommending. Friends, thanks for watching. See you again. Please guide me for my next topic, which you feel to be the need of today. Till then, bye bye. God bless.